So, when is a promise more than just, well, a promise? We all make them, right? But some promises, it turns out, carry the full weight of the law. Let's get into it and figure out what that magic ingredient is that turns a casual I promise into a legally binding contract.
Okay, let me throw a situation at you. You promise a friend you'll help them move. So they go ahead and book a moving truck, totally counting on you. But then something comes up and you have to cancel. Are you on the hook for that truck rental? Could they actually take you to court? Your gut probably says no, right? But the legal reason why is super interesting, and it all boils down to one single concept. And that big idea is something called consideration. See, in the eyes of the law, a promise floating out there all by itself is usually worthless. For a promise to be enforceable, it has to be part of a bargain, an exchange. It has to have a price. This old quote from a judge just nails it. Think of it this way. Consideration is what you use to buy the other person's promise. It's the thing of value that you bring to the table. I give you this, and in exchange, you give me your promise. Now, and only now, we've got something the law will recognize. Now, here's where it gets kind of cool. That price doesn't have to be money. The law sees it in two ways. It's either a benefit to the person making the promise, or, and this is key, it's a detriment to the person receiving it. A detriment just means you're giving something up or you're agreeing not to do something you have a right to do. As long as one of those is present, you're in business. And this old case is the perfect story to explain a really important rule. You have to be the one who paid the price. Here, a groom's father and his future father-in-law promised each other that they would both pay the groom some money. Well, the father-in-law passed away before paying up, so the groom tried to sue the estate, and he lost. Why? Because the groom himself hadn't given anything in return for that promise. He was just the lucky guy in the middle, not a party to the actual bargain. Okay, so we've established there has to be a price, but what counts? Does it have to be something with a clear dollar value? Or can it be something a little less tangible? Let's take a look. This side-by-side comparison is just fantastic for understanding this. On one side, you have a son who promises to stop complaining to his dad in exchange for a debt being forgiven. A court said, nope, that's too vague. That's not a real price. But on the other side, you have a nephew whose uncle promised him a bunch of money if he'd stop drinking, smoking, and gambling until he was 21. And that worked. Why? Because the nephew was giving up his legal right to do those things. He constrained his freedom, and that was a valid detriment. That was his price. This brings us to a super famous case that involves a deal that sounds pretty sweet. Back in the day, Nestle had this promotion where you could get a music record, supposedly for free. But was it really free? Let's see. So, here's what you had to do. You had to send in a little bit of money, and you had to include 3 of their chocolate bar wrappers. Now, the money was obviously part of the price, but the big legal fight was over those wrappers. I mean, Nestle was just going to throw them in the trash, right? So how could they possibly be part of the legal consideration? Well, the court said, oh yes, they absolutely can be. And this quote explains the whole thing perfectly. Basically, the law says consideration has to be sufficient, meaning it has to be real and have some value. But it doesn't have to be adequate, meaning it doesn't have to be a fair price. If the person making the promise asks for it, it counts. A peppercorn, a wrapper, whatever. Nestle wanted people to buy more chocolate, so those wrappers had a real commercial benefit to them, even if they ended up in the bin. All right, so we've talked about the what of the price, but the when is just as important. What happens if you've already done something nice for someone, and then they promise to pay you for it? The rule here is super clear. Past consideration is no consideration. A promise has to be for an exchange, not a reward for something you already did for free. In this case, a woman did a bunch of repairs on a family house on her own initiative. Sometime later, the rest of the family signed a document promising to pay her back for the work. But when it came time to pay, they refused. And the court agreed. The work was already done. It was in the past. So their promise was legally just a thank you note with no power behind it. Okay, so you're probably thinking the rules seem pretty clear now, right? Well, this is where the law throws a fantastic curveball at us. What if you're already supposed to do something under a contract, but then someone offers you more money to do the exact same thing? Is that second promise valid? Let's start with this classic story from the 1800s. A ship is in the middle of a voyage and 2 sailors desert. The captain's in a tough spot, so he promises the rest of the crew extra wages if they just get the ship home safely. They agree, they do the work, but when they get back to port, the captain says, nah, I'm not paying the bonus. And you know what? The court sided with the captain. The judge said the sailors were already contracted to handle the normal emergencies of the voyage, and a couple of guys deserting was just part of the job. They didn't provide anything new for the captain's new promise. They just did what they were already supposed to do.
Now let's jump ahead nearly 2 centuries. We've got a main contractor on a building project who's going to get hit with a penalty fee if the job isn't done on time. The carpenters they hired are behind schedule, so the contractor goes to them and says, "Look, I'll pay you extra if you can finish on time," even though that's what their original contract said anyway.
So what's the deal? Why did the carpenters get their extra pay when the sailors didn't? This table makes it all make sense. In both cases, they were just doing their existing duty. But in the carpenter's case, the court said the contractor got a practical benefit. By promising to pay more, they avoided that big penalty fee, they didn't have the hassle of finding new carpenters, and they got the whole project organized. That very real practical benefit was enough to make the promise of extra cash stick. But what about those times when the strict rules of consideration just lead to an outcome that feels deeply unfair? Well, thankfully, the law has a kind of safety valve for that, an idea designed purely to achieve a fair result. Take this famous case from World War II. People were fleeing London because of the Blitz, so a landlord agreed to cut the rent in half for a block of flats. After the war ended, things got back to normal. The landlord not only wanted to put the rent back up to the full price, but he also tried to sue for all the back rent that he had agreed to waive during the war. And this is where a legendary judge named Lord Denning basically said, "No way." He argued that even though the tenants hadn't provided any new consideration for the lower rent, they had relied on the landlord's promise. It would be completely unfair or inequitable to let the landlord go back on his word now. And this idea became known as promissory estoppel. But, and this is a huge but, there's a limit. Promissory estoppel is famously described as a shield, not a sword. That means you can use it as a defense, to stop someone from going back on a promise they made to you. But you can't use it as a weapon to launch your own lawsuit and force someone to follow through on a promise they made for free. It's about preventing injustice, not creating new rights. All right, we have gone deep into consideration, the price of a promise. So now let's just zoom out for a second and put all the final puzzle pieces together to see what a full-blown contract looks like. So consideration is the engine, but you need a few other parts for the car to run. You also need an intention to create legal relations. This is why your promise to take out the trash for your roommate probably isn't a contract. And you need capacity, which means the people making the deal are legally able to. For instance, they're not minors, which was actually an issue that came up in an early contract for the soccer star Wayne Rooney. So I'll leave you with this little challenge. Think about the last deal you made. It could be as simple as buying a coffee or as complex as a work project. Just take a second and try to spot the parts. What was the price? What was the benefit to one person? And what was the detriment to the other? Once you start seeing that exchange, you'll start to see the hidden architecture of promises all around you.